Welcome to our fourth section on estate planning. In our third webinar, we addressed the estate planning issues of Bob as a young adult, then starting a family with Carol and up through their working career. During that time, their plan focused on asset accumulation and protection. We're now going to jump ahead and revisit Bob and Carol's family when they're in their 60s. Different priorities have emerged now for them, priorities about legacy, such as what kind of impact will they leave and how do they want to be remembered. So their estate plan at this stage is now going to emphasize how they direct resources to family and community. So Lisa, can you start us off with an update on Bob and Carol?
Sure. Let's imagine for a moment that we were just learning of the couple's financial details and goals for the first time so that we can address the full scope of what they want to accomplish in their estate plan. Bob and Carol have 3 adult children now. 2 are married, 1 is single, 5 grandchildren. They have roughly 7 million in financial resources to meet their spending and gifting objectives. There's a primary residence and a vacation home in another state.
So we'll address all of these goals on the page, but I first want to point out that what you're seeing on the screen is typical both from what our clients express to us, as well as the type of conversations that we have with them. We're talking to our clients about these goals on an annual basis, and often more frequently than they're speaking with their own estate attorney. So it's very common that these goals evolve over time, and we actually are helping our clients. We're working with them to identify at what point they should go back and actually meet with their estate attorney. So I'll start by talking about the first goal. How much can we give to family and charity now without risk of depleting the resources that we need? As part of our financial planning process, we gather a complete picture of the vendor's assets, liabilities, income, and expenses. And then we create a projection, building in allowances for unexpected expenses like home repair and improvement, extraordinary healthcare expenses, things like that. And then we take this financial model and analyze the sustainability of the financial trajectory that they're on. So it's through this process that we can actually identify and quantify surplus funds that can be used for gifting to children and charity. Now, this isn't just a set it and forget it plan. Like, we don't create this one time and then we never revisit it again. This is going to be an ongoing conversation, an ongoing review of their financial trajectory to continually test out for feasibility to ensure that the vendors aren't at risk for running out of funds.
Great, Zach. I'll take goal number 2. So Carol plans to leave most of their estate to immediate family, but she's got a sister, niece, and nephew that she'd also like to include in her will. This is easily accomplished, pretty straightforward. You can leave any amount to any person you wish. Sometimes people use dollar amounts, others use percentages. And Carol might also include a statement to the effect that should her sister pass before she does, that her sister's portion be allocated to her niece and nephew. Goal number 3, the vendors are concerned about Bill, their son's ability to manage his inheritance. Bob and Carol can choose to have his assets held in trust. The trust would specify the conditions under which he would have access to funds. They would also name a trustee who would manage the funds and make sure that the terms of the trust were enforced properly. Sometimes people will first think of a family member or a sibling to act as trustee in a circumstance like this, and it's not such a good idea because it could be awkward at best, or at worst, it could create significant resentment and discord within the family. So I would look into a local, well-established professional fiduciary firm who could act as an executor or trustee in a circumstance like this. Moving to goal number 4. Federal estate tax is not a consideration for this couple because we can each leave 11 million to others when we pass away. However, in Washington state, unlike California, there's a much lower threshold at which inheritance taxes pertain. So each of us may pass 2.2 million on before estate taxes are considered. When you're a couple, the first death does not create a triggering system for this particular inheritance tax, but on the second death, it could. So typically we see testamentary trust brought out in the will that would um, essentially hold some of these assets in trust for the beneficiary spouse, thereby avoiding inheritance tax.
And I'll just add one point onto that. The current estate tax exemption is really high. The federal one is really high, but it is set to sunset, I think, sometime in 2025 or 2026, something like that. And the reality is that each time the government says this is permanent, this estate tax exemption is permanent, but I think in the time that I've been working in this industry, I've heard that like 3 or 4 times. So while the estate tax issue isn't relevant for the vendors today, it certainly could be in the future. And that's why it's important that we continue to revisit these goals over time. And then, so let's talk about the fifth goal. Bob wants to leave something to his university. So basically a gift to his university's foundation. One of the great things about people with philanthropic intent is that with proper planning, they can maximize the amount of money that goes both to their heirs and to charity. And so I think before I talk about how the strategy works, let me just back up and say, most people have a couple different types of assets in their estate plan. And I'll just break it down as retirement assets and non-retirement assets. Anytime an individual inherits a retirement plan, they're going to have to pay taxes anytime they take a distribution. So some portion of that money from an inherited retirement account is going to the government no matter what. The charity, though, well, they're a tax-exempt entity. So if you were to give a retirement account to charity and they take a withdrawal, they're not going to pay any taxes. So that money that would have otherwise gone to the federal government, if an individual took it, now gets to be kept by the charity. So what Bob can do is Bob can say, okay, I'll have my IRA go to the charity, and then my other assets, my assets in my trust, I'll give to my children or to my heirs instead. And when that happens, there's also something called a step up in basis for these non-retirement accounts, which basically wipes out all of the embedded taxation there. So what we've done just by moving around which person or which entity gets a specific account is we've eliminated all of the taxes that both of them would pay, and therefore maximize the amounts that all of them get.
That's a great point, Zach. If we move to goal 6, Carol has been talking about money and investing with her 2 granddaughters. And so she wants to be sure that they, in particular, receive the few individual stocks she has. So it would be a very simple matter to open up a transfer on death account and then name the 2 grandchildren as beneficiaries and simply plop those stocks into the account. And that could be accomplished very simply. Otherwise, she would just simply pass these or transfer these while she was still living to them. For other purely sentimental items with modest financial value like furnishings, artwork, book collections, etc., the vendors would complete a letter to family and friends. And we talked a bit about this additional resource in estate planning in earlier part of our series, but they would complete that to indicate any special things will go to individuals. Last but not least, we have an important goal that the vendors would like that none of their family would encounter any worries or frustrations in dealing with settling their estate. And Zach, I think you had a great observation you made a little earlier in our series where you said once you yourself have gone through the process of settling an estate, that you really recognize how valuable it is to have everything buttoned up. And as we move into our 60s and 70s and 80s, we are looking beyond our life expectancy. We're thinking about our expectations for our children and grandchildren and what we'd like to see happen in the community. And having that estate plan, making sure it's done, it's up to date, and it includes everything that's important to us, it just delivers fantastic peace of mind. Another comment I would make is that some families have great communication among the family members and siblings, and they might sort of implicitly have an agreement about how things should happen. But this sort of informal estate plan is one you really can't rely on. You might find that everything does not go as well as you planned. So it should be a formal written plan that your beneficiaries can rely on. Zach, would you like to summarize the steps the vendors would need to take to ensure that their estate plan is put in place properly?
Yeah, sure. I think that there are 4 things that they would need to do. One of them you've already hit on. It's basically to make sure that your formal estate documents are not only in place, but also up to date. And up to date means, or reasons, I guess, why things could get out of date are the vendors have a different intention for who they want money to go to. Or instead of that changing, maybe the estate tax law changes around them. And then I think the third one, which is maybe the biggest one, would be if there's a change in the makeup of the family structure. You know, somebody's born, somebody passes away. That's always an opportunity to make sure that the estate plan is up to date. The second thing that they should do is they should put together the financial inventory and letter to family and friends that we talked about in one of our prior sections. In these two documents, you have a list of all of the assets, where they're located, things like that. So your beneficiaries know, and your trustees and executors know exactly where everything's located. They know they're not missing anything. And this is also where you can list important information about passwords and insurance plans as well. And I think that it's important that you review these things, maybe semi-annually or at least annually. You can use the spring and fall equinox if you want to make sure you have a reminder to do it. But certainly the information that you would find on these 2 pages would change or could change frequently. The third thing that they should do is to communicate to executors, trustees, powers of attorney, all of these key people who are in their estate plan. Communicate to them not only where the original documents are located, you know, the 5 documents, the wills, trusts, so on, but also to provide them with a copy of the relevant documents as well, so they have them on file. I think the fourth thing is one that, at least in my experience, our clients don't think about frequently, but that is to introduce your family members to your estate attorney. I think that has a couple benefits. One, of course, is that if you pass away, you'll know, or your heirs will know, who to call. But then the second thing is there's a trusted individual already in place, and that relationship is already known. And so it just makes things a little bit smoother when the second person passes away.
That's great. You know, Zach, I don't know where this fits in our Bender case study, but I also want to mention that I've seen families do something for their parents as they age, for the family that strikes me. Those listening might have heard of legacy recordings. Families can hire a professional to interview and videotape your loved one, and it oftentimes will capture memories that wouldn't necessarily come through in family discussions. My sister and I did this a couple of years ago for my dad, and he's age 90 now. He's doing great, but we heard some things we hadn't heard before. One great memory he had to share with us was he would jump into the truck with his father, my grandfather, and they would drive 90 miles through gravel roads once a month to sing with an amateur barbershop quartet. And this was really a genesis of his love of music, and that early memory was something we hadn't heard him say in his own words. That was a treasure.
That's a really cool. You know, as you're saying that, I'm thinking actually about my aunts and uncles and cousins who they sometimes just sit around a table while I'm there, talking about stories about family members from decades ago. And I mean, I've usually heard those stories a few times, but when you hear it from them who witnessed it and experienced it, it brings a whole new like life to it. So that's really cool, and that's maybe something I want to do with my family as well. Okay, so let's wrap up here. So what you just heard in this section is an abbreviated discussion of the type of conversations that we have with our clients. And in particular, when we're working with them for the first time, because that's when we're really digging in and really assessing all of their legacy goals. There's a lot of other topics that we could have spoken about as well. We could have talked about irrevocable trusts, such as charitable trusts and life insurance trusts. We could have talked about actual strategies for minimizing estate taxes, as well as ideas for who to name for alternate trustees and executors. But ultimately, we wanted to keep this relatively simple. As we're continuing to work with the vendors going forward, we're going to touch on these topics at least annually. We won't go into the same level of depth, unless something happens in their lives that warrant that. And then, of course, we'll spend that time reviewing all of this information again with them. So at the end now of this 4-part estate series, if you've tuned into all 4, you have learned about the basics of the basic documents in estate planning, the common questions that we frequently come across when we're talking to clients about estate planning. And then, of course, you've heard about the estate planning concerns for 2 different people at 2 different points in their life. Not 2 different people, the same people, but at 2 different points in their lives. So as a final thought, I'll leave you with this. As financial planners, we are in the fortunate position to see how our clients' lives evolve over time. And depending upon what aspect of their financial life needs attention at any given point, we may be focusing, on retirement planning at one meeting and something else at a different meeting. But there's always some sort of interconnectedness. And I think you'll actually notice as we've gone through this, there's been several other planning topics that have come up related to retirement, related to philanthropy, things like that. And what we find as holistic wealth managers, people who talk about all aspects of financial planning, is that this approach serves our clients really well. We're able to connect the dots. We're able to say, oh, but what you're saying here kind of conflicts with this other goal in this other area of your financial life. We're also able to more readily find issues and troubleshoot things that might be on the horizon. And so at the end of the day, it's our hope that everybody gets to work with their advisor in that same way as well. And of course, if you're not, please give Lisa or myself a call. And then I'll mention one last thing on this last slide here. If you'd like to learn a little bit more about estate planning, you can please visit privateocean.com/estate planning. And then if you'd like a copy of any of the resources that we've talked about throughout this series, please feel welcome to contact Lisa or myself. And our email addresses are below. Thank you.